Hi, good afternoon. Uh, it's a very important judgment by Bombay High Court on the transfer pricing issue. The citation is R. Kuroma International India Private Limited versus Deputy Commissioner of Income Tax and others. So the core issue before the Bombay High Court was what is the effect of not completing the assessment within a period of 1 month from the end of the month in which the AO receives directions from the DRP. That is the question. So ARP is giving, I mean DRP is giving directions to the AO, but AO is not passing the order within 1 month, within a period of 1 month. So what is the effect? That was the issue before the Bombay High Court. Assessment year 2010-11. So hereafter, uh, R Chroma International India Private Limited, I will call it as AI. Don't think artificial intelligence. So AI filed return of income. It claimed a refund of rupees 3 crores on two accounts. One is tax deducted at source, other was advance tax paid. So the return was taken up for scrutiny by AO. AO made reference to transfer pricing officer for determining the arm's length price of international transaction involving corporate service charges. Based on that, AO passed a draft assessment order. So AI filed objections to the DRP against the draft assessment order. DRP confirmed the TP adjustment and directed AO to give effect as per section 144C13. Thereafter, final assessment order was passed by AO. So AI filed appeal before the Income Tax Appellate Tribunal. As far as there were one or two extra issues were there. As far as TP adjustment is concerned, tribunal remanded the matter back to the DRP while allowing the depreciation on goodwill and intangibles. So tribunal directed DRP to follow the precedents in AA's case for assessment year 2009-10. Agreed by the order of the tribunal, AO filed appeal before the High Court. Appeal was admitted by the High Court. AO in the meantime passed the order giving effect to tribunal order, allowing depreciation on goodwill and intangibles. But the AO's order did not reduce the TP adjustment because it was only remanded to the DRP. In the meantime, in obedience to the tribunal order, DRP issued directions to AO to re-examine the corporate service charges on the lines of its directions for assessment year 2014-15. AO, after receiving the order from the DRP, he did not pass order within 1 month from the end of the month in which the directions were issued by DRP. Hence, they said you cannot pass any order. As far as transfer pricing adjustment is concerned, order has become non-est. A writ petition was filed by AI before the Bombay High Court. So again, the core issue before the Bombay High Court was what is the timeline fixed by section 144C13 and what is the consequence of not giving effect to the DRP directions within a period of 1 month from the end of the month in which such directions were issued by the DRP. Bombay High Court analyzed the section 144C13. The constituents of it are as follows. One, first there had to be a direction passed by DRP as per section 144C5. Second, the directions passed by DRP ought to be received by the assessing officer. Naturally, if he did not receive, how can he pass the order? So he must have received that order. Third is it casts a burden on the AO by the mandatory language of the section to complete the assessment. And the fourth and important one is the AO ought to complete the assessment within 1 month from the end of the month in which such a direction of the DRP was received or is received. Bombay High Court said the language of section 144C13 is clear, unambiguous, and mandatory. It provides a mechanism for the steps that must be taken after the proceedings under section 144C5 are completed, that is DRP. The mechanism envisaged under the section has a strict timeline which cannot be deviated by the AO. The words used in section 144C13 are assessing officer shall is highlighted in conformity with the directions, and then the assessment without providing any further opportunity must be completed. All these things are there. Therefore, AO ought to complete the assessment, and that too in conformity with the directions given by the DRP under section 144C5 of the Act. The word shall in the section makes the provision mandatory. That is what the Bombay High Court said. Further, for the purpose of compliance of the provisions of section 144C13, the provisions of section 153 or 153B are expressly excluded. This is also noted by the Bombay High Court. Bombay High Court said in the present case, AO, that is assessing officer, ought to have completed the assessment order within a period of 1 month from the end of the month in which such directions of the DRP is received. AO does not have any discretion after the DRP issues directions, and he cannot deviate from the procedure envisaged under that section. The submission of revenue that section 144C13 that do not prescribe a specific time limit for the AO to complete the assessment within the specified time when the case is of a remand by the tribunal. It was not accepted by the Bombay High Court in view of the clear and unambiguous language of section 144C13. Bombay High Court said if the submission of the revenue is accepted, then the entire scheme and mandate of section 144C13 of the Act will become redundant. This is very important. The Act does not make any distinction between ordinary cases and cases on remand. I repeat, the Bombay High Court held the Act does not make any distinction between ordinary cases and cases on remand. The provisions of section 144C13 apply equally to both situations. Bombay High Court said section 144C13 mandates the AO to complete the assessment in conformity with the directions of the DRP, that too within strict timelines. Further, section 144C10 makes a clear provision that the directions of the DRP are binding on the assessing officer. Bombay High Court said the scheme of the section clearly provides that the AO is bound by directions and he has to complete the assessment within the timeline provided by the section. The reason for imposing a strict timeline in the section is that AO must follow the directions issued by the DRP, which are provided for his guidance in completing the assessment. It is a settled principle of law that where a statute requires something to be done in a particular manner, it has to be done in that manner. The statutory provisions cannot be waived or deviated from. Bombay High Court said if the argument of the revenue is accepted, then we will have to omit the mandatory provision from section 144C13 while reading that section. Such a route of interpretation is not permissible. All the words in the statute will have to be read and given meaning. That was the logic, reasoning by the Bombay High Court. Bombay High Court held, in view of the discussions made above, that the transfer pricing addition made by AO are barred by limitation and hence outside the purview of section 144C13. The AO cannot invoke the provisions of section 144C13 and complete the assessment because the time frame mandated by the section has already expired. So finally, Bombay High Court allowed the appeal. The crux of the issue is AO must pass the order within 1 month from the end of the month in which the directions of the DRP are received by him. Thank you very much. Have a great evening. Bye.